Item 2, the Work Injury Compensation Bill, second reading.
Minister for Manpower.
With your permission, Mr. Speaker, I have asked the clerk to circulate a handout to illustrate the key changes to the Work Injury Compensation Act to all members. Mr. Speaker, sir, on behalf of the Minister of Manpower, I beg to move that the bill be now read the second time. Sir, when an employee gets injured at work, he may claim damages under the common law or claim compensation under Work Injury Compensation Act, or WICA for short, but not both. Under the common law, the injured employee has to initiate legal actions and prove his employer's negligence to succeed. The WICA provides a cheaper and quicker alternative for an injured employee to claim work injury compensation. Under the WICA, the employee does not need to prove the employer's fault or negligence in order to be compensated. He will be compensated as long as the injury happened in the course of work. This is why we say WICA is a no-fault regime. In exchange, the employer's amount of compensation is capped under WICA. WICA has benefited many injured employees. Over the past 3 years, an average of about 15,000 work injury compensation claims were awarded, with a total payout close to $115 million per year for wage and lump sum compensation. All claimants, except 5 on average per year, were compensated by the deadline set by the ministry. The common reason for non-payment was because the employee was uninsured and faced financial difficulties. In such situations, MOM will assist the injured employees using the workers' fund. WICA has served its role of compensating injured workers well, but can be improved further in 4 main ways. First, the aims of MOM's work injury compensation regime should not be confined to compensation after injury has happened. It should also incentivize employers to prevent injuries from happening in the first place. Our Workplace Safety and Health 2028, or WISH 2028, aspiration for Singapore is to be among the best in the world in workplace safety and health standards. Second, some weak claims still take too long before payout is made. We will speed up and improve claims processing. Third, we will enhance insurance coverage and benefits for injured workers. And fourth, we will give greater assurance to employers so that WICA provides a balanced package of safeguards for both employers and injured employees. These are substantial changes, so the existing WICA will be repealed and replaced by a new act, the Work Injury Compensation Act 2019. Let me explain how the new WICA will influence companies to prevent injuries. In the recommendations of the WISH 2028 Tripartite Strategies Committee in April this year, they were convinced that the key in preventing injuries is aligning commercial interests of employers and insurers closer to preventing injuries. In short, we need to make good wish good for business. So more companies will then be self-motivated to prevent injuries. And one of the features in the new WICA is designed to influence employers to be more proactive on prevention by making the business impact of injuries more significant through its effect on premiums. Information transparency on claims history is essential in influencing employers to be safer. Today, there is no information sharing between insurers of their clients' past claim records. This has resulted in safer companies subsidizing the less safe companies, as there is little premium differentiation between these companies. The WISH 2028 Tripartite Strategies Committee recommended that MOM facilitates the sharing of weak claims data with insurers to sharpen the premium differentiation between safer and less safe companies. So Clause 33 of the bill will require insurers to share policy and claims information with the Commissioner. The relevant data will be made available to all designated insurers approved by the Commissioner. Furthermore, to facilitate more accurate premium pricing, all designated insurers will be able to verify their clients' declared aggregated workforce size and annual payroll through MOM's database. Clients' actual workforce size and payroll data will remain confidential, and will not be disclosed to insurers. What the insurers will know is whether their clients' declarations are consistent or not consistent with MOM's records within a certain margin of error. So with greater information transparency, employers with good safety records should be able to enjoy lower premiums. More importantly, less safe employers who are faced with higher premiums will have greater commercial incentive to put in place measures to prevent their employees from getting injured in the first place. Next, we have proposed 5 amendments which aim to speed up and improve weak claims processing. First, we will designate insurers to provide weak insurance under Clause 31. These designated insurers will be required to process insured weak claims in accordance with Clauses 36, 44 to 47. Today, insurers only process weak claims for temporary incapacity, or TI, fatal and permanent incapacity, or PI. These claims are processed by the Commissioner. In contrast, insurers are already processing the claims for all other types of insurance, such as life, medical, and travel insurance in Singapore. Other jurisdictions that also adopt the private weak insurance model, such as certain states in the US and Australia, have also required weak insurers to process all insured claims. Now, allowing insurers to process weak claims can help speed up processing, as insurers, who are the payers, do not need to do duplicative work to verify the documents and evidence obtained by MOM on the claim. Under the current system, having the insurers check back with the employers, the workers, and with MOM on the claim details can delay processing by up to 6 weeks. To ensure that the interests of all parties will continue to be protected under this new process, the Ministry will put in place a system of checks and balances. Clauses 31 to 34 allow the Commissioner to impose licensing conditions on designated weak insurers. The Commissioner may conduct third-party audits on insurers to make sure that they comply with the Commissioner's conditions. Any insurer that fails to comply with the Commissioner's conditions may be subject to administrative financial penalties, or in more serious cases, have their weak designation suspended or revoked. Under an insurer processing regime, employees and employers' interests will continue to be protected in 4 key ways. First, insurers have to comply with the Commissioner's protocol on claims admissibility. The grounds for liability for compensation under the new bill remains the same as that in the existing Act. We will set out guidelines to ensure that insurers do not reject claims which are currently admissible. Secondly, insurers do not have discretion in determining the compensation amount, as it is a fixed formula based on 3 factors. First, the doctor's assessment of the extent of the incapacity. 2, the worker's remaining years of working life. And 3, the worker's average monthly earnings, or AME. And third, in terms of processing, insurers have to meet the processing timeline set by the Commissioner to ensure that the injured employees continue to receive their compensation promptly. Finally, any parties that are aggrieved by the insurer's decision may raise an objection. Objections will continue to be adjudicated by the Commissioner. Another recommendation to speed up claims processing is to allow compensation to be based on the prevailing state of incapacity that is unlikely to change significantly after the date of assessment of the incapacity termed current incapacity, or CI. Today, about 80% of PI claims every year are resolved due to the time required for PI assessment to be made. The remaining, Today, about 80% of PI claims every year are resolved within 6 months. The remaining 20% take longer to resolve due to the time required for PI assessment to be made. The PI percentage is one of the factors determining the amount of lump sum compensation. However, delay in settling the compensation means the injured employee will receive their compensation later. Employers of injured foreign employees will incur higher upkeep and maintenance expenses, as well as the increased uncertainty for all parties involved. So we've consulted the WIC Medical Board members who advised that the extent of incapacity at 6 months after the accident is a close approximation of the eventual state of the PI in most cases. Clause 15 of the bill and the first schedule to the bill allow lump sum compensation to be computed based on the CI assessment that is made at least 6 months after the date of accident. This will help to expedite claims payout to the employee or their families for many long-drawn claims. The default expectation is for CI to be assessed as soon as possible after 6 months from the accident. Nonetheless, doctors will still have the professional discretion to assess for a PI at a later date if they believe that the extent of incapacity will change further for more complex injuries. Another cause of delay is disputes over AME. The Ministry receives about 360 AME disputes a year, and such disputes may delay claims processing by about 1.5 months. Currently, the Commissioner uses documentary evidence such as payslips to compute the employee's AME for purposes of WICA compensation. If the employee's payslip is not available, the Commissioner can compute compensation based on a co-worker's payslip. However, there are cases where there is no documentary evidence of the employee's or co-worker's payslip. Therefore, the first schedule of the bill will also empower the Commissioner to compute the employee's earnings based on a multiple of the employee's basic rate of pay, called the derived AME, if there is no other reliable evidence. Now, the derived AME will be set at the higher end of the industry norm. So this is to ensure that employees are not disadvantaged due to the absence of reliable evidence to compute the actual AME. We also propose to streamline the claim process to provide for more hassle-free auto-claim for fatal and serious injuries. Currently, an employee or his representative needs to submit a WICA claim application for fatal or PI compensation. To speed up claims processing and reduce risks of employees being misled or being ignorant of application procedures, Clause 35 of the bill provides that a claim is deemed to be made when the employer first receives notice of the accident. So insurers or the Commissioner will start to process the claims once there is a notice of accident without the employee needing to submit a separate claims application. So under this regime, employees who do not wish to make a claim under WICA can still opt out at a later stage. Now, delays can be caused by parties not cooperating with the Commissioner or the designated insurers in the claims process. To avoid such delays, we will make it an offence under Clause 50 for parties who fail to comply with the Commissioner's direction to provide information or documents to the designated insurer or the Commissioner necessary for claims processing. If accidents do happen, we are also enhancing the protection and benefits for injured employees. Under current WICA, employers are required to compensate all their injured employees, regardless of their salaries, where they work, the nature of work, manual or non-manual. To help employers fulfill this obligation, employers are required to purchase insurance for all manual employees and non-manual employees, or NMEs, working in factories earning up to $1,600 a month. The Minister will amend the WICA subsidiary legislation to align with the salary threshold for non-workmen under Part 4 of the Employment Act to give added protection to these employees. This will be done in phases to allow employers time to adjust. In Phase 1, we will extend compulsory insurance to non-manual employees earning up to $2,100 a month, regardless of where they work, and we plan to do this in 2020. Phase 2, we will further increase the monthly salary threshold to $2,600 a month, and we plan to do this in 2021. This expansion will require around 300,000 more employees to be covered by the compulsory insurance requirement. Nonetheless, we do not expect significant cost impact to businesses, as MOM's Conditions of Employment Survey indicates that close to 90% of employees today are already covered by WIC insurance, even though employers were not obligated to cover some of them, but employers have covered 90% today. By doing so, these companies ensure that they could meet their WICA obligations in case of accident. Now, the first schedule to the bill extends compensation to employees on light duties due to work injuries. This will put them on par with employees on medical leave due to work injuries. So employee injured at work could be given medical leave or light duties, depending on his fitness to work on the availability of light duties. Employers would benefit from an employee who is fit enough to carry out light duties, as there will be shorter downtime from work and some restoration of productive capacity. However, an employee on light duties may be earning less than his usual salary. This is because he is likely to work at a lower intensity and duration and will miss out on overtime pay or allowances that he would normally have received if he was not injured. The first schedule requires employers to compensate the difference between what the employee earns on light duties and his AME, which is what he normally earns, including overtime, bonuses, and allowance. Compensation is payable only if the employee's actual wages while he was on light duties is less than what he would have received as his AME compensation under WICA. This is to ensure that an employee who is on light duties due to work injury is not worse off than an injured employee on medical leave, and because the one on medical leave will have been given compensation of AME. So in addition, the WICA subsidiary legislation will require employers to report any instance of employees on medical leave or light duties due to work injury. This is to address the concern that some irresponsible employers may try to avoid reporting of work accidents by attempting to influence doctors to give fewer days of medical leave or light duties. We will simplify the reporting requirements for accidents with less than 4 days of medical leave or light duties to minimize the administrative burden for companies. Today, an injured employee's PI assessment is typically done by a doctor directed by the employer. However, MOM has received feedback, one from member Louis Ng as well, that some errant employers may attempt to influence doctors to give inadequate medical leave, or some doctors may be overly conservative and underestimate the percentage of PI. To ensure that there is proper and fair assessment of the extent of work injury sustained by the employee, Clause 37 of the bill, which requires an employee to attend medical examination required by the employer, has an exception which enables the Commissioner to allow employees to undergo medical examination by another doctor doing the PI assessment. So this will be exercised, for example, if there are concerns and prima facie evidence that the quality of care and incapacity assessment by the employer's doctor may not be adequate and fair. So MOM will also update the WICA compensation limits in the first schedule of the bill to keep pace with wage growth and healthcare costs. This is a regular update which we do once every 4 years. It prevents the real value of compensation from being eroded by inflation. So the compensation limits for death and PI will increase by about 10% to 225,000 and 289,000 respectively. This is to account for the growth in median gross monthly income since the last review. The compensation limit for medical expenses will be raised from the current $36,000 to $45,000, an increase of about 25%. This will ensure that the limit for medical expenses continues to cover more than 95% of all WICA claims medical expenses. While we work to make the WIC framework better for employees, it is equally important to ensure that the interests of our employers are also protected. Employers who buy insurance policies that do not adequately cover their WICA liabilities may not be able to obtain reimbursement for compensation paid. We have come across cases where construction companies bought WICA policies that do not cover accidents arising from working above a certain height and certain activities such as digging and piling. But these are precisely the type of work where accidents are more likely to happen. So to better safeguard employers' interests when buying WIC insurance policies, Clause 26 of the bill allows the Commissioner to prescribe a core set of standard items for WICA-compliant policies to ensure that insurance policies cover employers' WICA liabilities adequately. So we will also make insurers accountable for the policies they offer to employers. Clause 26 of the bill requires any insurer who has sold to the employer a policy purporting to be a WICA-compliant policy to compensate the injured employee according to the standard terms of a WICA-compliant policy. So this is on top of it being an offence under Clause 30 for insurers to sell policies purporting to be WICA-compliant when they are not. Additionally, Clause 30 makes it an offence for any insurers not approved by the Commissioner as a designated insurer to sell a WICA-compliant policy. Under current WICA, the Commissioner can order the employee to refund to the employer any medical leave wages paid if the employee withdraws his claim. If the accident was subsequently determined not to be work-related or if it was a false claim. We will extend the refund to lump sum compensation and medical expenses. Clause 16 and 54 of the bill enable the Commissioner to order the claimant to refund the employer or the insurer if the employer or insurer had paid for the lump sum compensation or medical expense due to error or false or misleading information. This is on top of it being an offence under Clause 62 for any person to obtain compensation by providing false or misleading information. Sir, other than the 4 key highlights highlighted above, we will be making other amendments to the Act. Under the current Act, parties have up to 14 days from the receipt of the notice of assessment to raise objections to the Commissioner. If no objection is raised within the 14-day timeline, the notice of assessment takes the effect of an order of compensation, and such orders cannot be appealed to the High Court. We will amend the Act to allow late objections with valid reasons, and when we had come across a case where the employee had given the completed objection form to the employer to submit to the Commissioner. However, the employer failed to submit the employee's objection form within the prescribed 14-day timeline due to administrative lapses. While the employee had appealed for the Commissioner to accept the late objection, current WICA does not allow for late objections irrespective of the reasons. Therefore, we have provided in clauses 46 and 49 of the bill to allow the Commissioner to accept late objections if the late objection is due to error or fraud by another person. On penalties, Clause 61 increases the maximum fine for non or late payment of compensation from the current $10,000 to $15,000. In addition, we will create a new offence under the same clause for failure to deposit compensation with the Commissioner when directed. Both offences are benchmarked to non or delayed payment of salary under the Employment Act. To deter repeat offenders, clauses 25, 35, 61, 62 and 68 provide for the maximum fines for a second or subsequent offence to be doubled. Mr. Speaker, sir, in conclusion, our goals for the new Work Injury Compensation Bill are first to influence employers and insurers to be more proactive in preventing injuries from happening in the first place. Second, we aim to speed up and improve claims processing. Third, to enhance protection for employees. And last, to give greater assurance to employers when buying WIC insurance. And this will make the WICA better for both employers and employees. We have worked with tripartite partners and other key stakeholders to design the new WIC bill to support our WISH 2028 vision. With these changes and all other ongoing and upcoming efforts under the WISH 2028 strategy and continued strong support from our tripartite partners, we endeavour to reduce workplace accidents and raise Singapore's WISH standards to be among the best in the world. With the new WIC bill, if passed, will be effected on 1st September 2020. This will give sufficient lead time for the industry to adjust to the changes. Sir, I beg to move.